Good morning, all of you. How is everybody doing today? So, welcome back to our class on corporate and other laws. We are already on the third chapter. I know we are running behind schedule a bit. However, we will cover up the chapter number 3 first, and then chapter number 4 we will start with today. So that's okay. It's sometimes there is some delay happening as per the schedule, but that doesn't mean that we will leave certain topics. We'll be covering everything that is required for your syllabus point of view. So before beginning with class for today, I hope all of you remember what all we had done in the previous class in terms of the concept of trading of securities on a stock exchange, where we were talking about, when we were talking about section 40, we spoke that whenever a company, a public company wants to issue its share securities to the public, it needs to be listed or approved, or permission has to be taken by a recognized stock exchange, for which an application needs to be filed, right? And after the filing of the application, if the stock exchange does not give the permission, they cannot proceed with the issuing of their or selling of their securities, right? So after you need to understand that all of these requirements that we were talking about, these were because a company wants to bring a public offer of its security. So few things that we need to understand in the background. Question number one: why is company bringing a public offer and diluting its shareholding in the company? Why is the company doing that? The company is doing that because it needs money for operation of its business, for expansion, for adding a new vertical to the business, for increasing its sale network, its distribution network, right? It is doing it for money. So whenever a company is doing something like this for money, it would want that the public offer that it is making, it is successful. So let's say company is in requirement of 10 crore rupees minimum, bare minimum, it needs 10 crore rupees to execute the plan of business expansion that it wants to. So let's say it rolled out shares for 15 crore rupees. So the company would want at least 10 crore worth shares get subscribed for. So to ensure the success of the public offer that is made by the company, that is being made by the company, there is a group of people who provide support with respect to that. And who are these people? These people are called underwriters. Now, who is an underwriter? These people are nothing but they are financial institutions or individuals or a partnership firm or a company who give a guarantee that if the shares are not subscribed for by the public, they will subscribe those shares, and in return, they get commission for the same. Now, how much they will subscribe for the share, whether they will subscribe all the shares or they will subscribe the minimum number, whatever is left behind, or they will subscribe a certain percentage of shares, that depends on the terms and conditions of the agreement entered between the company and entered between the underwriter, right? So this entire concept of underwriting is to give the company the confidence that their public offer would be a success. Now, this topic of underwriting as such is a very, very important topic. You often get to see questions in this area in your exam. Yes, it is one of the key, or you can say favorite topics of the examiner. So here I have briefly tried to explain what is meant by underwriting. This is not what is provided for in section 40. It is just for your understanding. So let us just walk through what I have written here. So underwriting an issue or share or debenture involves entering into a contract with a person known as underwriter, who may be an individual, partnership firm, or company, undertaking that in the event of the shares or debentures not being subscribed by the public or only a part of it being subscribed, he shall take up the balance. So basically, he's a sort of guarantor. Okay, so underwriter is that person who provides that guarantee. It could be the person, it could be a firm, it could be an individual, or it could be a company, right? Now, does company law permit providing underwriting commission? Is it permitted under Companies Act? Yes, it is permitted. So when you look at clause 6 of section 40, it says that a company may pay commission to any person for his subscribing or agreeing to subscribe to its securities subject to the prescribed condition. Now the question arises, how will that commission be paid? What will be the amount of commission and what are the rules and regulations for the same? So Rule 13 prescribes the conditions for the payment of commission, right? So section 40 tells you that it is allowed to pay the commission to such a person. Rule 13 prescribes the conditions for the payment of commission. So the first condition here is the payment of such commission shall be authorized in the company's article of association. So the first requirement is authorization in the article of association of company. So if the articles of association does not authorize, they will not be able to pay the underwriting commission. Now, how can the payment, from where the payment for underwriting commission could be done? It can be paid out of the proceeds of the issue or the profit of the company or both, right? Third point is, what would be the rate of commission? So company law says that where the underwriting is for shares, the commission shall not exceed 5% of the price at which the shares are issued, or the rate which is authorized in the articles, whichever is less. So let's say that the amount, the percentage authorized in the articles of association is 3% for the shares. So will the company be allowed to issue 5% commission? No, they will not be allowed to 5% under commission, because the law says that whichever percentage is less, that would be the amount that will be permitted. So let's say if your articles of association says that underwriting commission would be 10%, will you be allowed to pay? No, because Companies Act says that it shall not exceed 5% of the price at which the shares are issued. So the capping here is 5%. So if there is a offer of sale of shares, the maximum amount of underwriting commission that can be given is 5% of the price at which the shares are issued, right? Similarly, in case of debentures, we have 2.5% of the price at which the debentures are issued. Now, or the amount that is specified in company's article, whichever is lesser. Okay. Now, so this is a standard protocol. So if you would see the entire process of allotment of securities, drafting of prospectus, approvals from the stock exchange, requires a lot of paperwork, right? So we have institutions and people who are specialized in this. So underwriters are such people who help you with bringing or with giving you a comfort that all the money that is being invested for raising funds from the market, it will not go into drain, right? So for remembering this the requirements under underwriting commission, I have developed a mnemonics that if you want, you can write it down. NCD PAR. So there is a mnemonic here that you can mention, that is NCD at par. Now, N stands for not paid on shares not offered to public. That means underwriting commission will be offered only on shares that are offered for sale to public. You can write it down. N stands for not paid for shares, not offered for sale to public. So only those shares which are offered for sale to public, for that share, underwriting commission will be paid. Now, the contract that is entered between the party for the underwriting commission, that needs to be submitted to the registrar. So C stands for contract with underwriter filed with the registrar, right? D stands for disclosure in prospectus. So whenever there is a provision which says that you will sign an underwriter and you will give a commission to them, so you will have to disclose in the prospectus who the underwriter is and what the commission is being paid to him. So these are the requirements. P stands for the payment. So the payment for the underwriting commission is made out of profit or the proceeds. So P stands for paid out of profit or proceed. A stands for authorized by AOA. So there has to be an authorization in the article of association. And R stands for rate. So for shares, it is 5% or the amount mentioned in AOA, whichever is lower. For debentures, it is 2.5% or the amount mentioned in the AOA, whichever is lower. So this payment for the shares can be made either out of the proceeds of the issue, that is the amount that is generated due to sale of the share, or from the profits of the company, or both. Is this clear, guys? Have you written down this mnemonics? Do you want me to repeat this NCD-PAR? So in furtherance to that mnemonics, let us go to the provisions that have been given here. There are certain requirements for disclosures of the particulars in prospectus. What are they? The name of the underwriter, the rate and amount of the commission that is payable, and the number of securities which is to be underwritten or subscribed by the underwriter, absolutely or conditionally. Okay. Next point says that there shall not be paid commission to any underwriter on securities which are not offered to public for subscription. So if it is a internal placement, then there will not be any underwriting commission. So it is only for the public offer, whether IPO or FPO, for which underwriting commission is payable. And copy of payment of commission to be delivered to the registrar. So the contract for the payment of commission is delivered to the registrar at the time of delivery of the prospectus for registration. D stands for disclosure in prospectus. Guys, I am repeating the mnemonics. You can write it again. So the mnemonics for underwriting commission that can help you remember the key contents is NCD-PAR. N stands for not paid on shares, not offered to public. Not paid on shares, not offered to public. N stands for not paid on shares, not offered to public. Right? C stands for contract with underwriter filed with ROC. The contract with underwriter filed with ROC. Right? Contract with underwriter filed with ROC. D stands for disclosure in prospectus. D stands for disclosure in prospectus. P for parrot. P stands for paid out of profit or proceeds. P stands for paid out of profit or proceeds. A stands for authorized in the AOA, which is Articles of Association. Authorized in the AOA, which is Articles of Association. R stands for rate. For shares, the maximum rate is 5% or the amount prescribed in AOA, whichever is lower. For debentures, it is 2.5% or the percentage prescribed in the AOA, whichever is lower. Are we good here, guys? Everybody is good. Have you written this? Okay. Now, so there is an example here, a public limited company which wanted to raise funds through public issue of shares had applied for listing of its shares in 3 recognized stock exchanges. However, only 2 exchanges had given permission for listing. So can the company proceed with the public offer? Tell me. Will the company be allowed to proceed with the public offer? Can I have answers to this question? So I would want you to solve this question on your own. This is a very basic question. All of you are taking a lot of time and we are short of time today. This is an example from your study material only. So you can check it there, right? The next example that I've been given here is the board of directors of a company decide to pay 5% of the issue price of shares as underwriting commission to the underwriter. However, the article of association permit only 3%. The board of directors further decide to pay the commission out of the proceeds of the share capital. Are the decision taken by the board of directors valid? Can I have the answers here? Yeah, so the correct answer would be that only 3% would be allowed. They will not be allowed to pay 5% because the law says the amount on a higher side could be 5% or the amount prescribed in AOA, whichever is lower, right? So Surya is asking me, ma'am, what is meant by absolutely or conditionally? Absolutely means the in totality. Conditionally means coming with terms and conditions. So whenever an underwriting contract comes with certain terms and conditions, so let's say the underwriter says that if you are issuing 100 securities, I give my guarantee to subscribe or underwrite for only 15 securities. So that is a conditional undertaking. Or maybe I will I will subscribe or take a guarantee for subscribing to the securities only when this is done. So this is what is meant by conditionally. Where it says absolutely, it means absolutely in totality without any terms and conditions. So see, you need to understand that whenever two parties enter into agreement, it is subject to terms of agreement between them, what they agree. There are no fixed guidelines for that. So yes, there can be certain prescribed rules provided by the law, just the way we have seen here that the amount of underwriting commission has been prescribed for. You cannot go beyond that. But other than that, what are the number of securities they will subscribe, when they will subscribe, how they will be paid for, all these things are open to agreement between the parties, right? So this is about underwriting commission. Okay, are we good here? Are we good till here? Now, proceeding on to the allotment of securities by the company. So what is the process? How are the securities allotted? As of now, we had read that whenever a company wants to make a public offer, they need to have a prospectus. The prospectus needs to be registered with the registrar. The prospector needs to have certain information, like it needs to be dated, it needs to be signed, it contains certain disclosure, like what is the date of publication, whether it should contain a statement that the requirement of the laws have been complied with, right? So there are list of steps. So the first step that we talk about was prospectus ka drafting. So once the prospectus is drafted, it has to be filed with the registrar. Then it is published, inviting offers from public for the purchase of shares in the company. Now, what will company do? The public will study the prospectus that is being offered by the company, and based on the offer, it will put in the application for subscribing to the shares of the company along with the application money. Now, what is the minimum percentage of application money that has to be received? So it is minimum is 5% of the nominal amount of share. So this is what is prescribed under law, right? So after the application money and the minimum subscription capital has been achieved. So minimum, what is the minimum subscription capital here? The minimum subscription capital is the 90% that needs to be subscribed for always, right? So this requirement of 90% of the minimum subscription has been provided by the SEBI in the CDR rule. So when you read the provisions of section 39, you will get to see that the requirement of providing the guidelines for allotment of securities had been given to the SEBI. So SEBI in the CDR rules has said that minimum 90% of the subscription has to be there. But this requirement of minimum subscription is not required for offer for sale. It is not required for offer for sale, right? And there has to be a minimum application value, which is 5% of the nominal value. But for offer for sale, the minimum application value is 100%. So these prescriptions are given in the CDR guidelines. So if that minimum amount has been prescribed for, shares will be allotted. If not, the amount will be returned. How this entire procedure of allotment of securities goes by as per the procedure laid down in the law, that we will walk through one by one. So we will take up the rules and the section 39 together to understand how does the allotment of security takes place. Okay, I'm sorry, Ritik, I missed your query. What was your query? So Ritik is saying, ma'am, the directors can alter AOA by passing special resolution and can alter 3% to 5% and can do so, ma'am. Yes, they will be able to alter the memorandum of association, but I think the requirement of they will be able to alter the AOA. That's not a really big problem. But in any situation, they have to abide by the benchmark. So they cannot alter the AOA to say that they will proceed 10% underwriting commission. Even if they do that alteration, they will not be permitted to pay 10% of the underwriting commission. So underwriting commission that they will be able to pay will only be 5% on a higher side for the shares and 2.5% for the debentures. And also, please remember the underwriting commission, the percentage of the underwriting commission that is agreed to be paid to the underwriter has to be mentioned in the prospectus as well, right? Lalita, which second point you are asking? I'm sorry, please specify the query. It is difficult for me to understand the first point and the second point. Okay. Now coming to the allotment of shares by the company, right? So let's walk through the points one by one. First requirement is the receipt of minimum amount is must. So no allotment of security of a company which is offered to public for subscription shall be made unless the stated amount in the prospectus as the minimum amount has been subscribed, and the amount that is payable on the application for the amount so stated have been paid for and received by the company. So minimum subscription value has also been received and minimum application value has also been received. So in your study material, you will see they have not told the percentage 5% or 90%. This is because the percentage that we are talking about, they are provided, they are governed by SEBI under CDR regulation. So we are not studying SEBI for students. That is why law says the minimum amount that has been provided for has to be prescribed. Now, the amount payable on application on every security shall not be 5% of the nominal amount of security or such other percentage or amount as may be specified by SEBI by making regulation in this behalf. So, Companies Act says it should not be less than 5%, but SEBI can provide for any other percentage. And I think, if I am not wrong, SEBI in its CDR regulation has provided for 25% as the minimum nominal value on the application, right? So nominal value means minimum amount that you will receive as application money of the share. Nominal value is the value at which the shares are offered, right? Now, what if the minimum amount that has been provided for is not subscribed? So let's say your minimum amount says that 98% of the capital has to be subscribed and you do not receive the application for that amount. In that case, whatever amount has been received on the application, that has to be returned to the people. And this date that we see, that from how many date we need to achieve the minimum amount, that is within a period of 30 days from the date of issue of prospectus or such other period as may be specified by SEBI. So if as per law, you only go by the law that we are studying here is company law. So as per Companies Act, if the minimum amount is not subscribed within a period of 30 days from the date of issue of prospectus, then the money that has been received on the application will be returned. And this money has to be returned within a period of 15 days from the closure of the issue. And if such a money is not paid, then the directors of the company and the officers who are in default, they will be jointly and severally liable to repay the money with the interest at the rate of 15%. Right? So, 3 points that we have to remember here. Firstly, there is a requirement that the amount stated in the prospectus as the minimum subscription is to be subscribed. The sum payable on application in respect of minimum subscription has to be received by the company. So these two conditions need to be fulfilled for a company to be able to make a public offer of to be able to complete the public offer, to be able to allot the securities. Now, this amount of minimum requirement has to be received within 30 days of issue of prospectus or such other period as may be specified by the SEBI. If the minimum required amount is not received within a period of 30 days from the date of issue of prospectus or the period specified by SEBI, the company will have to return the amount in such time and manner as may be prescribed. Now, what has been prescribed? So, Rule 11 says that the amount has to be returned 15 days from the closure of the issue. So this is given under Rule 11. So Rule 11 says if the minimum amount has not been prescribed and the sum that is payable on application, that the percentage, minimum 5% of the nominal value of application has not been received, then that amount will have to be repaid within a period of 15 days from the closure of the issue. And if this money is not repaid, the directors and the officer in the default will be jointly and severally liable to repay the money with interest at the rate of 15%. So they will not just have to return the application money, they will also have to pay interest on that amount from the period of expiry of 15 days. So within a period of 15 days, that amount has to be repaid. Now, to which account that amount will be sent? So Rule 11.2 says that the amount will be refunded to the same bank account from which the subscription was remitted, right? And right, so this is the situation when the company is unable to allot the securities due to failure of fulfillment of minimum subscription requirement or application requirement, right? Now, what if the company allots the securities? So if the company allots the security, they will have to file a return of allotment with the registrar. This return of allotment is filed in form number PAS3 along with the fees within 30 days of allotment, right? So two situations. Prospectus has been issued. Prospectus prescribes for minimum subscription value and minimum application value that is to be received. Either the company will fulfill the norms, that will it will receive the minimum subscription and minimum application amount, or it will not. If it will not, it will not be permitted for the company to allot the security, and it will have to return the money within 15 days of the closure of issue. If the company does not return the money, the director and the officer of in default will be jointly and severally liable, and they will have to return the money with the interest at the rate of 15%. If the requirements are fulfilled, the securities will be allotted. When the securities are allotted, the return for allotment of securities have to be filed within 30 days in the form number PAS3 along with the fee that is prescribed for. Is this clear? Guys, is this clear? This basic layout of allotment of securities for public company, is it clear for everybody? Now, there are certain details that are be provided with when you are filing the return for allotment in the form number PAS3. So what are these information? So this is a return of allotment. What is this allotment of? Allotment of securities. So who are this being done to? The securities will be allotted to the individuals who have put in the application for subscribing to the securities and their applications have been approved, right? Now, so in the return of allotment, the details of this allottees has to be given. The list of the allottees containing their name, addresses, occupation, the number of securities that are allotted to each of these allottees. And this list of allottees that is submitted, it has to be certified by the signatory of the form PS3 as being correct and as per the records of the company. Along with that, whenever the securities are issued for consideration other than cash. So as of now, we were understanding a situation where the company has issued an offer. Under the offer, applications are made by the people who are interested. They give the money in the form of check or demand draft or NEFT. And if they are shortlisted, the securities are offered to them. But there are a lot of situations under business where securities are issued for consideration other than cash. Now, what could be those situations? Now, consider a scenario where company A and company B together are entering into a JV agreement, which is joint venture agreement. As per the agreement, company B is supposed to provide a technical know-how, right? So let's say a company wants to manufacture chips that are used for AI. So company A has a hold in Japan in the selling, right? Company B is a company of US. It wants to expand its business in Japan as well. So what would company B want? Company B would say, let me collaborate with a company who has a good distribution network for these goods in Japan. So they will collaborate. So company B will say, I will provide you the technical know-how on manufacturing the chip. You manufacture it and sell it. So there could be terms and conditions in the agreement where it would be written that in return of the technical know-how that has been provided by the company, shares will be allotted to them or securities will be given to the company B. So here, what is the consideration? Consideration is not money, but the technical knowledge, right? So these could be the situations where securities are to be issued for a consideration other than the cash. So wherever there is such a scenario where securities are to be allotted for consideration other than the cash, in that case, the copy of the contract in which this transaction is recorded and this contract has to be duly signed has to be submitted to the registrar along with the form PAS3. Right? Also, what about situation where the contract that we are talking about is not reduced to writing? It has not been written. In that case, it will be considered that if the agreement would have been written, what would be the duty payable on it, and that duty along with the details, the terms and conditions of the contract is submitted along with the PAS3 and it is deemed to be an instrument within the meaning of Stamp Act. Along with that, a report of a registered valuer also has to be submitted. Now, this valuer will put in the valuation of the consideration. So here we are talking about situation, we are not talking about cash, but kind. So let's say I say in return of this watch, I will get shares of the company. Now, how much shares I will get will depends on the value of the watch. Who will determine the value of this watch? The value of this watch will be determined by the valuer. So the valuer is the person who gives a statement on what should be the value of the watch, and accordingly the number of securities are allotted. So the report that is issued by the valuer, that also has to be provided for. Are we? Then, along with the report of the valuer, if the kind of share is being issued is a bonus share, in that case, the resolution that is passed in general meeting for issue of bonus share, that has to be attached in form PS3. Then the valuation report of the registered valuer when shares have been issued pursuant to 62(1)(c), which is equity shares that are convertible preference shares are listed on stock exchange. So there for those company have to submit the report of the registered valuer also. Now the question arises, what if there is a default in complying with these provisions? So if there is a default, then the company and the officers who is in default shall be liable for a penalty for each default, 1,000 rupees for each day during which default continues. The maximum penalty that can be awarded is rupees 1 lakh only, right? So this was about the allotment of securities. So if you see this chart here, for allotment of securities, the first requirement is subscription of minimum amount, right? Application money, that the minimum application money has to be received, right? If it is done, either the shares will be allotted or it will not be allotted. So if the minimum requirement has been received within 30 days from the issue of prospectus, then shares will be allotted. If not, the amount that has been received has to be returned within 15 days of the closure of issue. Whenever company makes an allotment of security, it will have to file a return of allotment within 30 days. If you do not comply with this provision, there is a penalty. The return of allotment has to be filed in the form PAS3. Now, this PAS3 has certain attachments like resolution in case of bonus share, where the consideration is not money, in that case a report of the valuer, the contract under which the securities are being allotted, the details of the allottees, all these information is submitted along with the form PAS 3, right? Are we good here? Surya, what you couldn't understand in terms of return of allotment? Mahima, what kind of notes you would need? So you are asking me to provide you some notes so that you are able to connect to you, because I am just explaining the concept. So Mahima, what do you want me to explain? This is what is expected, because if I don't explain the concepts to you, how would you attempt the case study based questions? Right? So what kind of notes you want? Let's say there is a mnemonic that I provided for to you for underwriting commission. But there are few things that even as a faculty, I would suggest that the way of learning varies from person to person. So it is not necessary that the notes I provide is good enough for you to be able to attempt the questions in the examination. If you have understood the concept, you will always be able to attempt the questions. If you have not understood the concept, you have only the notes, you might not be able to attempt because you need to see the way the questions are being put up in the CA examination, that is changing drastically. Now you have a lot of case study based questions. Direct questions have been reduced, right? So understanding concepts is really important. For revision also, Mahima, see, the notes are just coming out of the Bare Act only. So let's say here we were talking about the allotment of securities. So the first point, what did I tell you about allotments of security? The first point is the requirement of minimum subscription. What is the requirement of minimum subscription? So the law says that a company will not be able to allot any of the securities until the amount that is provided in the prospectus as the minimum subscription is subscribed, and the sum that is payable on application in respect of minimum subscription is received, right? So SEBI says that the minimum subscription has to be 90% as per the CDR regulation, and the nominal value as per the law is 5%. So let's say total 100 shares are offered for sale, or it has been offered for subscription by the company. The minimum subscription requirement is 90%. That means the company should have received the application for at least 90 shares, right? Now, the nominal value that has, and the value of each share is rupees 10, right? Or let's say rupees 20. Now, what is the minimum application value? It is 5% of the nominal value. So 5% of rupees 20 will be rupees 10, right? So 10 into 90, rupees 900. So if the company has received rupees 900 and subscription for 90% of the share, only then the company can proceed with the allotment of securities. If not, they will have to refund or return the money, this rupees 900 that was received by the company, that amount will have to be returned to the people from whom that money was received. So this is what is note says. What other notes would you need? That is difficult for me to understand. Guys, for attempting your examination for case study with based question, I would always say the general procedure that is followed: state the facts. What is being said in the question? What does law say about such a situation? Like, So let's say we have a question here that after having received 80% of the minimum subscription as stated in the prospectus, Raksha Detective Instrument Limited, before finalization of the allotment, withdrew 50% of the said amount from the bank for the purchase of certain asset. Thereafter, it started allotting the shares to the subscriber. Rashmi, one of the subscribers, was allotted 100 equity shares. She, however, refused to accept the allotment on the ground that such allotment was violative of the provisions of the Companies Act. What would you think would be the situation here? So if such a question is there in front of you, how would you answer this? I'm waiting. Please answer this question. Guys, please answer this question. What would be the answer here? So here they are saying that the company has received 80% of the minimum subscription. So since the minimum subscription, 80% of the minimum subscription as stated in prospectus, since the minimum subscription has not been achieved, it prohibits the company to allot the share. So you need to understand, if the minimum subscription has not been achieved, the company will have to refund the amount, because you need to understand here the company is governed by the SEBI CDR guidelines, and SEBI CDR guidelines says that at least 90% has to be the minimum subscription amount. So it is only 80% of the subscription amount that has been received. So in that case, company does not have the authority to allot the shares. So thus the company was violative in allotment of shares, right? So Sneha is asking me, ma'am, should the minimum subscription be 90%, including the shares taken up by the underwriters, or exclusive of that man? So you need to understand here that underwriter is just a guarantor, right? So as per the law, for a minimum subscription, it has to receive the application of 90%. So, and 90, and as such, you need to understand minimum subscription is the amount, that bare minimum that is needed by the company for the purposes that it is offering. And underwriting, then when we look at it, underwriting could be for the totality of the shares as well. So these concepts are not connected. These are very different concepts. So as per law, allotment of securities can happen if the minimum subscription is received, has to be 90%, right? Okay. So are we clear on this concept of allotment of securities, guys? Are we good here? Shall we proceed with the liability for misstatement? Please say a yes or no. For students who are saying that law is theoretical in nature and it is difficult to remember, I would always say that when you read the law, break it down into into points. So supposedly, let's take the example of shelf prospectus. So when we were talking about shelf prospectus, I said that shelf prospectus along with the information memorandum together will be deemed to be a prospectus. So while you are making your notes, you can write shelf prospectus plus IM, which is information memorandum, together is equal to prospectus. So this is how you will have to break down things to be able to remember. Breaking down is important because if you don't break it down, it will be difficult for you to remember things. Now, this will happen only when you read it on your own and break down the questions, right? Now, leaving behind the methodology of answering questions, let us proceed with the liability for misstatement in prospectus. So when we were talking about the prospectus, we had studied that there is a golden rule that whenever a prospectus is being drafted, the company has to ensure that the information that is provided in the prospectus is accurate, and any information that may affect the decision of an investor is not missed, right? Now, what if there is a misstatement in the prospectus? So if there is a misstatement, there is a criminal liability also, and there is a civil liability also. So what is the criminal liability and what is the civil liability? That we will understand. So whenever there is a misstatement in the prospectus, Section 34 of the Companies Act, it fastens a criminal responsibility. So whenever there is a criminal liability, you need to understand there is a concept in IPC which says mens rea. Mens rea means intention, right? So the person has deliberately, with the intent to mislead the person, has included incorrect information. In that case, there will be a criminal liability. So if you, let's go through the provision that is provided in Section 34. Where a prospectus issued, circulated, or distributed includes any statement which is untrue or misleading, every person who has authorized the issue of such prospectus shall be held guilty for fraud involving an amount of at least 10 lakh rupees or 1% of the turnover of the company, whichever is lower, punishable with imprisonment and fine under Section 447. So he will be punishable for fraud under 447 of Companies Act 2013. So where the prospectus has a untrue or a misleading statement, then every person who has authorized that document will have a liability, right? And the amount that we are talking about here for fixing a criminal liability is at least 10 lakh rupees or 1% of the turnover of company, whichever is lower, right? Now, when you look at the punishment or penalty for fraud, it says that any person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of turnover of company, whichever is lower, shall be punishable with imprisonment for a term which shall not be less than 6 months. So minimum imprisonment is 6 months, but which may extend to 10 years. Plus there is fine. What is the fine? It shall not be less than the amount involved in the fraud, but it could extend to 3 times of the amount. So let's say the fraud was for 10 lakh rupees, then the person will be liable for imprisonment from 6 months to 10 years, and he will be liable to the amount that is involved in fraud or 3 times the amount that is involved in fraud. Now, where the fraud involves a question in public interest, in that case, the term of imprisonment shall be minimum 3 years. So where the public at large was hampered. So let's say a company who is manufacturing a food product the food product that is being offered for sale contains one of the ingredient which is harmful for the health, and the packaging or the label of that food product does not list that ingredient. So what is happening? The public at large is being affected. The public interest is being affected. So in that case, where the fraud in question involves public interest, in that case, imprisonment shall not be less than 3 years, right? I think I gave you an incorrect example. I'm sorry. Sorry, this example does not suit this situation, but you can understand that wherever the statement in prospectus is such that it affects the public at large, where the number of people who are affected is huge, just the way it happened in Satyam scam. In that case, the term of, or the Sahara scam, the term of imprisonment will not be less than 3 years, right? The third situation is where the fraud involves an amount of less than 10 lakh rupees or 1% of the turnover of the company and does not involve public interest. In that case, the person who is guilty of fraud will be punishable with imprisonment up to 5 years or fine up to 5 lakh rupees or both. So there are 3 situations here under penalty for fraud. First situation, guilty for fraud, right? What is the amount? Amount is at least 10 lakh rupees or 1% of the turnover of the company, whichever is less, right? So in this situation, what will be the imprisonment? Imprisonment will be 6 months to 10 years. Penalty will be not less than the amount involved or 3 times the amount, right? Second situation is the fraud that we are talking about is having an amount of at least 10 lakh rupees or 1% of the turnover of the company, but it also involves public interest. So where the fraud involves public interest, the term of imprisonment minimum will be 3 years. So where there is no public interest, the minimum imprisonment is 6 months. But where there is public interest, the minimum imprisonment is 3 years. The third situation is where the amount is less than 10 lakh or 1% of the turnover of the company, whichever is lower, and does not involve public interest. Amount is also less, public interest is also not involved. So the punishment here will be maximum imprisonment will be only up to 5 years and the fine will be maximum up to 50 lakh rupees or both. Are you clear on this? Will you be able to break it down into table? Guys, is this clear? Yes, you are right, Janki. There is no minimum period of imprisonment in the third case, ma'am, but it can extend up to 5 years. Now, that will depend on the facts and circumstances of the case, and depends on the jury whether they award imprisonment or they only award fine or they award both. Who is saying that 10 lakh limit is not available here in your study material? I think it's given. Let me have a look. This 10 lakh limit that you will get to see, that you will see when you are reading section 447, bacha. So 447 is given at the end of your study material. You will be able to find that, right? So I have mentioned this section 447 here itself because it keeps coming again and again. So when you will look at fraud, you will get to see the section 447. I'll tell you also on which page number it is provided for so that there is no confusion on this. Just 1 minute. So it is point number 9. If you look at there you will get to see page number 3.35 of the new study material, point number 9. It contains the punishment for fraud under section 447. So if you look there, you will be able to find the limit of 10 lakh rupees. Guys, don't worry, I'm coming back to section 34, 35, 36, and 37. I have mentioned punishment for fraud here itself because this term fraud keeps coming in these 4 sections. That is why I mentioned it pre-hand, so that it does not create any confusion in your minds. Right? Now, coming back to the understanding of the term fraud, because repeatedly you get to see the word fraud in terms of civil liability and the criminal liability. So what is meant by fraud? So does the fraud always means doing something or including something, or it would include omissions also? So if you include a incorrect information, or you omit or conceal certain important information, all of it would be fraud. Even abuse of the position which is available to the person with an intent to deceive or to gain undue advantage, that all comes within the ambit of the fraud, right? Anmol is saying book में fine का amount नहीं है. Okay, Anmol. Anmol, both the things are there. Please don't get confused. It is in point number 9, right? So, when we talk about liability and what will be the defense that will be available to the people. So the person who have been affixed with the liability, civil or criminal, sorry, I'm talking about criminal liability here. So the person who has been affixed with the criminal liability, what is the defense that is available to him? So this person on whom the criminal liability has been affixed, if he proves that the statement or omission was immaterial, or the information that he had put in, he had reasonable grounds to believe that the information was true or the omission was necessary. Now, supposedly, when we talk about such statement or omission was immaterial. Now, supposedly, the name of the director of company is Shweta, right? Now, there is some error in the prospectus where instead the name of the director being Shweta, it is mentioned as Shwet. A is missing. So, if the person who has been held liable for criminal liability, if he can prove that the omission or the statement or the misstatement that has happened that was immaterial, then he will not be affixed with the liability. Or let's say the statement that was included by the director or the authorized people or the people who have authorized the prospectus was an expert statement. So they simply copied the statement that was provided by the expert, and they would say that I don't have knowledge about this area. I went by the statement of the expert and I had reasonable reasons. I'll have to justify that I have reasons to believe that the information that is being provided here are true. So in that case also, he will not be affixed with the criminal liability. Right? Is this clear? So criminal liability is there by the people, on the people who have authorized the prospectus, but we have defenses available as well. What are those defenses for criminal liability? Where we can prove that the misstatement is immaterial, or the person who is authorizing the prospectus has reasonable grounds to believe that the statement was true or the omission was necessary. So Surya, situation is whenever the section says that the person or the officer in default will be punishable for fraud under section 447. 447 will be applicable. So throughout companies law, wherever liability of fraud is affixed, section 447 comes into picture. Shoaib is asking me, ma'am, the fine says that at least 10 lakh rupees or 1% of the turnover, that is the amount of ghapla that we are talking about. So if the turnover of 1% is 8 lakh rupees, then which one we will take? The amount which is lower. If you look at the language of section 447, it says any person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of the turnover of the company, whichever is lower, shall be punishable with a imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years. Lalita is asking me, ma'am, if misstatement is there in prospectus without any knowledge and no intention, then section 447 will apply. Well, section 447 will apply if the prospectus has been authorized by that person and his signature is there. However, let's say the directors had no knowledge of prospectus and he issues a public notice that a prospectus has been issued to which he has no knowledge and he does not give his approval to the same. In that case, his liability will not be affixed, but he will have to release that public notice for that purpose. What was your question, Mustafa? At least and whichever is lower? So at least and whichever is lower will come into picture. Let's say the turnover of the company, 1% of the, Mustafa, I'm answering your question. So let's say 1% of the turnover of the company turns out to be 10 crore rupees, right? And the amount that is involved in fraud is only 7 lakh rupees, right? Right? In that case, can we invoke 447? No, because 447 says any person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of the turnover of the company, whichever is lower, right? So the lowest amount for which we can affix the penalty is 10 lakh rupees. Is that clear? अनमोल, बुक में फाइन अमाउंट नहीं है. बुक में फाइन अमाउंट है, अनमोल. I am reading from your book only, and it is written that section 447 describes punishment for fraud. According to it, any person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of the turnover of the company, whichever is lower, shall be punishable with an imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Where is the amount not mentioned? Please read carefully, Anmol. It's not possible for me to keep on repeating this. Okay. Now coming further, now coming to the civil liability. So civil liability will be applicable where a person has suffered loss or damage because of misstatement. Criminal liability gets involved wherever there is a fraud and misstatement in the prospectus, irrespective of the fact whether the damage has been incurred by anybody or not. Fraud has been done, misstatement is there, amount is involved, there will be a criminal liability. But civil liability is for situation where due to that misstatement, a person has suffered loss or damage. So this person who has suffered this loss or damage will be able to recover that amount from the people who have been affixed with the liability for misstatement. So are you clear with this concept of civil liability and criminal liability? Are you clear with this concept of civil liability and criminal liability? So the first point arises, who are these people on which the civil liability is affixed? So first requirement is there is a loss that has happened to subscriber due to misstatement. Now you need to remember here, the loss has happened to the subscriber. So where you directly apply for the shares of the company under IPO and FPO, and the shares were allotted to you and you suffered damage due to misstatement, then you can invoke section 35. If you have purchased the shares from the open market, from a trading market, in that case, you are not able to invoke section 35. So you have to be the subscriber, not just a shareholder. So where the loss is sustained by subscriber, then he can claim for compensation, right? From whom can he claim the compensation? He can claim the compensation from the director, from the expert who has given his statement and the consent, from the person who is authorized to be named as the director, from the promoter, and the person who have authorized the issue of the prospectus. From all these 5 people, damages can be claimed. Anmol, please read page number 3.35 and 3.36 in new study material. Repeatedly putting the same question doesn't sound good. I think some of the students have already confirmed that this information on penalty is there on page number 3.35 in new study material. So please do not put that question again and again, right? Now coming back to the civil liability, the first requirement for civil liability is there has to be a loss. This loss or damage has to be sustained by reason of misstatement in the prospectus, right? Then the person who has, the subscriber who has suffered the loss will be able to claim the compensation. From whom he will be able to claim the compensation? He will be able to claim the compensation from the director of the company, from the people who has authorized himself to be the director, like the proposed director, from the promoters of the company, from the people who have authorized the issue of the prospectus, and the person who are named in the prospectus as an expert, right? From all these people, he will be liable to claim the damages. Now, so is this liability, or do we have a defense from this liability? Yes, that there are certain defenses that are available to the people on whom the civil liability is affixed. So no person shall be liable for misstatement where such person proves that he had withdrawn his consent before the issue of the prospectus. So let's say there was a person who had given his consent to become a director of the company, but before the prospectus were issued, he withdrew his consent and the prospectus was issued without his consent. In that case, his liability will be removed. Where the prospectus was issued without his knowledge. So where the prospectus was issued without the knowledge or consent of the person, and then when he became aware of its issue, he gave a reasonable public notice that it was issued without his knowledge, then also he will not have a liability, right? Thirdly, where the misleading statement is made, is purported to be made by an expert, or it is an extract of the statement given by an expert, and it was a correct and fair representation of the statement, in that case also, there will be no civil liability on the 5 persons that have been named, right? So this is the civil liability for for misstatement in prospectus. Now, what is the liability on defrauding? Where it is proved that the prospectus has been issued with an intent to defraud, then the applicant of the securities of the company or any person or any fraudulent purpose, every person that has been referred shall be personally responsible without any limitation of liability for all or any of the losses or damages that have been incurred by any person who subscribe to the securities on the basis of such prospectus. So what's happening? Where there is an intent to defraud, where deliberately a statement was included for defrauding, in that case, the liability for misstatement, the civil liability for misstatement will be unlimited. There will not be any limitation and the safeguards will not be available, right? So in case of criminal liability, every person who has authorized with the prospectus is punishable under 447. Defense was that the misstatement was immaterial or he had a reasonable ground to believe. When we talk of civil liability, the company's director, the proposed director, the promoter, the expert, the people who have authorized are affixed with civil liability. They will have to pay compensation to the investor. Defense is he withdrew the consent, he believed on the information, or it was issued without his knowledge or public notices issued. So these are the liabilities for misstatement. Is this clear? Surya is asking me, ma'am, can you say an example? How can he prove that he was not aware of such an issue, being KMP? So let's say if Mr. X has given his authorization, if he has the signature on the prospectus, then he cannot escape. Let's say Mr. X, who is the KMP, who he was not in India, he was in US at the time. During his absence, the company decided to issue a prospectus and authorization and everything was taken and he had given his consent also. But without showing him the prospectus was issued in the market. In that case, he can prove that he was not in the country. There are no communications where the copy of prospectus was given. There is no communication where it can be proved that he had signed the prospectus. In that case, his liability will be, he can do away with his liability. Tejas is asking me, ma'am, what is the difference between civil liability and criminal liability? So you need to understand, bache, wherever there is civil liability, it is only the it is only the fine that is involved. A civil liability is compensated with money. So a person has suffered damages, loss of money, that loss is compensated with money. But when we say criminal liability is something which affects the public at large. And whenever there is a criminal liability, you will always see that there are provisions. The penal consequences are imprisonment and fine both, because such an offense can affect the public at large. So with the Satyam scam coming into picture, with the Sahara scam coming into picture, with even the Nirav Modi scam, the entire scam of Mehul Choksi, Nirav Modi, we have seen that such kind of scams can affect the public at large. So whenever the offense is of criminal in nature, which can affect the society at large, there you will always see a criminal liability. Let's say the offense of murdering someone. So it's such a grave offense that it affects the society at large. But let's say you just misinterpret something or you do not return somebody's 10 rupees. So yes, you have suffered loss because your money was not returned to you, but it will not affect the society at large because you were not returned your rupees 10. So wherever there is an intention to defraud the public at large, we see that there is a criminal liability. When there is a deliberate intention to defraud public at large, then there is a criminal liability. So is that clear? Pavan, what was your question? Please, guys, don't feel hurt if I miss somebody's question. The queries keep popping up every second. And as a faculty, I just don't have to answer the queries. I have to teach you also. So don't feel offended if I miss one of your queries. Well, Pavan, for your query where you are asking the meaning of defraud, I would request you to, no, Pavan is not asking me meaning of defraud. What was your query, Pavan? I think I missed it. What is the difference between omission and concealment of fact? So omission is just wiping off the information. Concealment of fact is, let's say the company's turnover is 1 crore rupees. So it has not included 1 crore, it has written 0.9 crore. Or let's say company had issued dividends in the past 3 years. But the dividend that was issued by the company, it was not issued out of profit, but it was issued out of reserves. So the reality is the company has actually suffered losses in the previous 3 years. So this you can say as concealment of fact. So important fact that actually the company was suffering from losses is a concealment of fact. Surya, the situation is if the person has given the consent to be the director of the company, and a person, the moment he becomes the director of the company, he has certain liabilities, right? But there could be situation where he does not has knowledge, which will be dependent on the facts of the case. So in the court of law, we prove no knowledge through different kinds of documentation. It is not that we can always prove it. It will depend on the facts and circumstances of the case. Just the way in case of criminal liability, you have often seen that people take the plea of alibi. What is the plea of alibi? When on the date of murder, which happened in New Delhi, I was in Chennai. So when I am not in Delhi, how can I do the murder? Similarly, we have defenses available for civil liability also. How that defenses will be proved, that would depend on the facts and circumstances of the case. So these are the things that cannot be explained to you, or there are no fixed blanket for that or straight line formula that I can give you that this is how you will prove. No, he has director, because he is a director, he has liability. But if he can prove that the prospectus was issued without his knowledge, he can issue a public notice for the same, right? Are you clear, Surya? So I'm skipping on the examples that you can do on your own. Now, proceeding to punishment for fraudulently inducing a person to invest money. So where a person is deliberately, fraudulently, by providing incorrect or deceptive information, is induced to investing money in a company, that a person will be punishable for section 36. So let us go through what is given in section 36. Okay, so section 36 says any person who either knowingly or recklessly means carelessly, makes any statement, promise, or forecast which is false, deceptive, or misleading, or deliberately conceals any material fact to induce another person to enter into or to offer to enter into any agreement for acquiring, disposing, subscribing, or underwriting security, or any agreement, the purpose or the pretended purpose of which is to secure a profit to any of the parties from the yield of securities, or an agreement with a view to obtaining credit facilities from any bank or financial institution shall be liable for fraud. So wherever a person makes statements with an objective to induce a person to invest money or to get some benefits or credit facilities, he will be liable for fraud. Rahul, you are complaining that I am taking some students' query again and again. So Rahul, if you try and understand, for me, every student is equal, and I try to take up the query of all the students. But it's just that the chat keeps scrolling down, and sometimes I end up missing few queries. And if I remember rightly, Rahul, I have been taking all your queries in your previous classes. So instead of complaining, rather focus on the content that I'm delivering here, right? So just putting on a complaint all the time that, ma'am, you're not taking my query, another person is saying not taking my query, that's not going to help you clear your exam. If you focus on what I'm teaching, you'll rather be in a better position. So please be careful when you put in such an allegations on the teachers. We are faculties. You will have to respect teachers and maintain the decorum of the class. We are taking online classes. That does not mean anybody can say anything. Okay, coming down to class action suits. So this concept of class action suits was brought into picture only after Satyam scam. So earlier there were no provision where public at large, let's say multiple people have been affected by a fraud and they could together file a case. So every petitioner, every person who was defrauded had to file an individual application. But then came class action suits, which is a gift of Companies Act 2013. In fact, class action suits we also got to see when this all drama about MSG in Maggie noodles Nestle had happened. So class action suit is a suit which allows multiple people who have suffered a common harm to file a case together as a group or class. This is what is meant by class action suit, right? So it is not a remedy which is available to an individual. It is a remedy that is available when a group of people have been harmed by a common offense. So where there is a common harm, a large number of people have been affected, they can proceed with class action suits. More details on this you really need not know. This is all you need to understand here. Amrisha is asking, ma'am, is punishment under 447 same for all misstatement? Amrisha, wherever there is a fraud, the person will be punishable with 447. Under 447 also there are 3 situations, and depending on the situations, the liability is affixed. Okay, the next topic that we talk about is private placement of securities. So, as of now, what we were discussing, we were talking about public placements, public offer of securities, whether it is first offer or it is further offer, right? Now we are going to talk about private placement. So can anybody tell me private placement? Can anybody tell me what is the meaning of private placement, or what do you understand by the term private placement? Answers? People, I'm waiting. What do you understand by private placement? So private placement is another very important topic that we get to see in the examination, and it is another one of the favorite areas of the examiner. So when we had started this chapter, if you remember, we were talking about that allotment of securities is done, offer of securities is done by public company and private company both. Public company does it through offer for sale, IPO, and public offer, right? But there was, and private placement as well. But private company could offer its securities only through private placement. Now, how does this private placement happens? Ritik, I have seen your query that you want me to repeat the content of the prospectus, which I will, but after completing private placement, on your request, I will repeat the contents of the prospectus. Don't worry. Prakash is saying private placement is the issue of shares to existing shareholders. No, dear. Issue of shares to existing shareholder is more of rights issue and bonus issue, not private placement. No, you are incorrect. Yes, Pooja, you are right. Securities issued to selected people, right? Right, Shruti, private placement is done by public and private company to issue securities to selected group of people. Right? Right. So, private placement is also a way of raising capital. Now, the private company, if you remember the definition of private company given in section 268, section 2, subclause 68, clause 68, it specifically says that a company which restricts the transfer of its shares. So, when we say it restricts the transfer of its shares, that means such a company will not be able to make a public offer, but it can make a personalized private invitations for raising money. So it is a way of raising capital that involves the issue of securities to a relative number of selected people, right? So you select the people, you decide on the person from whom you want to raise the capital, and you send the invite to them for the same purpose. So in the case of public offer, you see that the information is in public domain. There is advertisement, there is notice, there is issue of prospectus. Nothing of such thing happens in private placement. The information is shared, definitely. But the information is shared only to that selective person from whom the company wants to raise the money, or that selected person from whom the company deems fit that it wants to raise the money in return of securities. So, guys, I don't know if you have ever seen Shark Tank. Has anybody watched Shark Tank? So in Shark Tank, what happens? There is a jury of investors. So there are different people who are basically entrepreneurs. They come to on Shark Tank. They pitch their ideas, not their ideas. They pitch their business. So let's say there was a contestant who was making dog poop bag. So in US, there's a lot of culture that if you have dog and if your dog poops on the street, you need to have a bag to collect that poop. You're not supposed to leave it on the streets just the way you do it in India. So in other countries, you're not supposed to do that. So he had made a special type of dog poop bag with out of a different material, right? So in that case, what he did, he went to the Shark Tank and he said that I am looking for, let's say, $10 million in return of 10% stake of my company. So what is he doing? He's diluting his shares, 10% of his ownership in return of money. So this is also a type of private placement because he's going to that selected few investor. Well, this kind of funding we generally called as investor funding or angel funding, right? But this was just a way of explaining things to you. Shweta, don't worry about point number 8. I will cover each and every point. Nothing will be missed. You don't have to worry so much. I haven't completed the session as of now. Once I am done with the session and then if I miss on something, please mention that, ma'am, you have missed something. And also understand we have limitation of time. If one or two topic which is not really very important and does not have very important concept, I might miss it. right? So let me finish my section first. Okay, I'm sorry. Guys, I must tell you, you really break my flow of the class by putting such things. Now, this point, ma'am, you missed point number 8. Point number 8 has come twice. It becomes really difficult to focus on the class. So kindly hold on to such queries. Let me finish my class. If something is left, I will do it. Have patience at least. जो पढ़ा रही हूं उस पे ध्यान नहीं है, जो छूट गया है, जो नहीं दिख रहा है, सारा फोकस वहां पे है. You should always focus on the content that is being delivered, guys. See, I am not supposed to give an exam, so don't behave as if you are invigilating me and you are deciding on who I am and how am I teaching. Focus on what is being taught to you. Now, coming to the private placement. So the provisions pertaining to the private placement is provided under Section 42 of the Act. So this Section 42, along with the Rule 149 of the PAS rule, provide for the private placement of shares. So firstly, what we will do, we will go through the provisions and the rules, and then I will summarize it for you, right? So the first point here is applicability. So a company may, subject to the provisions of Section 42, make a private placement of security. That means a public company and private company both can make a private placement of securities. Second requirement is that the offer is to be made only to a selected group of persons. So what's happening here? That you select the people, you identify the people. So the board of directors, they identify the people to whom the offer for securities is to be made. Is there a limitation on the maximum number of people to whom this offer of security is to be made? Yes, there is a limitation that maximum number of people to whom the offer of securities is to be made is 200. So the law says number shall not exceed 50 or such higher number as may be prescribed. So the higher number that has been prescribed is 200. So the limit of the number of people to whom these shares can be, to whom a request or an offer, an internal offer for security is made is 200. But there is a point that you have to remember here. Whenever you are counting this limit of 200, you exclude the qualified institutional buyers and employees of the company who are being offered securities under employee stock options. So QIBs and ESOPs, employees offered securities under ESOPs, are excluded when counting on the limit of 200 members. Is that clear? And this limit of 200 is for each financial year and for each type of securities. So you can make an offer of to 200 people for preference shares, to 200 people for equity shares, and to 200 people for debentures, right? So this thing you have to remember, that there is a limit of 200. Now, so going through the rules that are provided here. So according to Rule 14, subclause 2, an offer or invitation to subscribe securities under private placement shall not be made to persons more than 200 in the aggregate in a financial year. Now, supposedly, okay, an offer for shares for the company was made for 150 people in the let's say 100 people in the financial year 1920, and the company in the financial year 2021 wants to again make a private placement offer to 200 people. Will it be allowed to do that? Will it be allowed to do that? Guys, will it be allowed to do that? Well, so when we are talking about this private placement offer for this limit, when we are talking about the company is a private company, we have to also ensure that the maximum number of members in a private company will not be more than 200. So the subscriber to the shares of the company cannot be more than 200. So if 100 people have already subscribed to the share, in the financial year 1920 or 2021, in 21-22 only 100 more people can become subscriber to the shares, because they will be listed in the memorandum as the subscriber, and the maximum people who can be the member of a company, of a private company, is limited to 200. So that limit also has to be taken care of when we are talking about private company, right? So the limit that we see here of 200 is a limit of aggregate in a financial year. First point, this limit is applicable for each kind of security, that is equity share, preference share, or debenture share. So we can have invitation to 200 people for equity shares, invitation to 200 people for preference share, invitation to 200 people for debenture. But at any time, whenever there is subscription to security is happening, can the number of members company exceed 200? They cannot. It's not possible. Also, when you are calculating on this limit of 200, QIBs, which is qualified institutional buyers, and the employees who are offered securities under ESOPs are excluded. QIB plus ESOPs excluded for this limit. So you can mention it in your notes if you want to summarize and keep it. Now, however, this limit of 200 that we see here, it is not applicable to NBFCs and HFCs. So non-banking financial companies and housing finance companies, to them, this limit of 200 will not be applicable. But for that, they will have to comply with the regulations that are made by the RBI or the regulations that are made by the National Housing Bank in respect of offer or invitation to be issued on private placement basis. Okay. However, if the RBI or the National Housing Bank do not have similar regulation, in that case, they will comply with the regulations that are provided here in Companies Act. Is that clear? Aditya, in a financial year, it is an aggregate of 200 for each type of security, right? Aniruddha, qualified institutional buyers are certain people whom the SEBI thinks that they do not require higher level of monitoring or guidance or regulation. So these are different from regular people like us who buy shares. These are people who have knowledge, who are sitting with an experience. So there are guidelines for being registered as a QIB. For that, we will have to delve into SEBI that we do not need as of now, right? The limit of 200 is for every company. So the conditions that you are seeing here is applicable to every company who makes a private placement of securities. So every company who makes a private placement of security, it will have to comply with the provisions contained in Section 42 and the conditions that are provided for in Rule 14 of the Companies Prospectus and Allotment of Securities Rule. Now, coming to the manner of issuing private placement offer and application. How does a company issue a offer of private placement and application? So, section 42 subsection 3 says, a company making private placement shall issue private placement offer and application in form and manner as may be prescribed to identified person whose name and addresses are recorded by the company in such manner as may be prescribed. Also, it is provided that the private placement offer and application shall not carry any right of renunciation. Right of renunciation means the person cannot do away with his right. That means, supposedly, I have a right to vote. Can I renounce that right to vote? No. So similarly, the right to private placement, he cannot renounce that. He cannot do away with it. So what happens here, that board of director identify the people whom they want to issue an offer. The details, name and addresses of those people are recorded, and then an offer is made. So how this offer is to be made, the details of this will be prescribed under the rule. Now let us look at, so this is this point 3 that you're reading here. It is subsection 3 of section 42. So there are certain explanation provided here. So as per explanation 1, what is meant by private placement? So private placement means any offer or invitation to subscribe or issue of securities to selected group of persons by a company through private placement offer cum application, which satisfies the condition in section 42. Now, who is a QIB? QIB will carry the meaning that is defined in SEBI by SEBI in the SEBI Act, right? So I'm not delving in the details of the SEBI. Now, explanation 3 talks about when a private placement shall be deemed to be an offer to the public. So explanation 3 talks about situations under which even though offer is a private offer, but it will be deemed to be an public offer. So let us look at what does section say about it. It says, if a company listed or unlisted makes an offer to allot or invites subscription or allots, enters into agreement to allot securities to more than prescribed number of people. So if the company has made an offer to more than prescribed person, the company has allotted to more than prescribed number of people, or it has entered into an agreement to allot to more than prescribed number of people, irrespective of the fact whether the payment of the securities has been received by the company or not, or whether the company intends to list its security or not. It will be deemed to be an offer to the public, and the company will have to govern by the provisions of part 1, where we talk about public offer. So if a company exceeds this limit of 200, it will be deemed to be a public offer and not a private placement. Surya, you are right. In case of debenture, every year company can go with 200 people for debentures. Now, whenever a company has to make a private placement, it needs to pass a special resolution. However, there are certain twists and turns to this requirement of special resolution. So when you look at rule 14.1, it says that a company shall not make an offer or invitation to subscribe to securities through private placement unless the proposal has been previously approved by the shareholders of the company by a special resolution for each of the offer or invitation. So whenever a company wants to make a private placement, then a special resolution has to be approved. It has to be passed under a special resolution by the shareholders of the company. So whenever a special resolution has to be passed, a notice along with the explanatory statement. So notice of the meeting along with the explanatory statement is sent to the shareholders for the approval. So there are certain requirements of the kind of information that are to be included in that explanatory statement. So what is the information that is included here? Particulars of the offer, including date of passing of board resolution, kind of security offer and the price at which security is being offered, basis or justification of the price at which the offer or invitation is being made, name and address of valuer who performed the valuation. So valuer will decide the price of the shares, so of the security. So the details of the valuer has to go. Amount which the company intends to raise by way of such securities, and the material terms of raising such securities, proposed times, schedule, purpose, object, contribution being made by the promoters or directors, and other relevant information that might be helpful, right? So all these information goes in the explanatory statement. Surya, there is, I don't, do not use short forms that I'm not able to understand. Your query is not clear. Pavan Kumar, your query is not clear. FV of 5 and FV of 10, what is this? I can't understand. I'm sorry. Please put in your queries clearly. So, as a general principle, we have seen that special resolution is needed wherever company wants to issue shares on a private placement. However, there are exceptions where the need for special resolution is not there. What are those situations? Where the company is making an offer or invitation for non-convertible debentures, and the amount that is proposed to be raised through this offer does not exceed the limit that is specified in section 180 subsection 1C. Now, what is the limit prescribed in 181C? The limit is the existing borrowing of the company plus the proposed borrowing. So the money that is already showing in the balance sheet as debt, and the money that the company is wanting to borrow through debentures, they should not be greater than or equal to paid up share capital plus securities premium plus free reserve. So where the amount that is to be raised through non-convertible debenture does not exceed the limit of 181C, in that case, just passing a board resolution is enough for doing a private placement. Special resolution is not needed, right? Further, when you look at the third proviso to Rule 14, it says, where an offer or invitation is for non-convertible debenture and the proposed amount to be raised through such offer exceeds the limit that is given in 181C, then it is enough if the company passes a special resolution only once in a year for the offer or invitation throughout the year. So let's say throughout the year, company makes multiple invitation. For the first time, it makes invitation to 10 people, then it makes to 20 people, then again it makes to again 5 people, then it makes to 30 people. In that case, if the special resolution has been passed one and the company is making an offer for non-convertible debenture, even though it exceeds the limit, then passing special resolution only once a year is enough. Is this corrected? Is this clear? Now, the third situation says that where an offer or invitation is made to qualified institutional buyer, in that case only, passing a special resolution only once a year for such an allotment is enough. So in these cases, they need not file, they need not go for repeated filing or repeated passing of special resolution. Once a special resolution is passed for non-convertible debenture, which exceeds the limit, it's enough. Where the offer is being made to QIB, special resolution once a year, enough. If the offering is for non-convertible debenture which does not exceed the limit of 181C, board resolution is enough. Is that clear? Guys, is that clear? Yes, Ramya, you are absolutely right. You will have to keep on updating yourself and going through amendments every day. As a professional, you will have to keep on reading law. What you are reading today might not be applicable tomorrow. It might change. Surya, now I got your query. Like in case of private company, the maximum number of members are 200. So this is why when the allotment of equity share capital or preference shares is happening, we also have to ensure that the limit of members is 200 in a private company. So there, the limitation of section 268 will also be applicable. Right? So if the number of members has already reached 200, in that case, company will not be able to offer shares to new people. It can offer further dilute the shares to its existing shareholders, or it can issue debentures, but it will not be able to issue shares to new members. New members will not be added beyond 200 in case of a private company. Is that clear, Surya? Okay. So are we good on this point on requirement of special resolution and exceptions where special resolutions? Are we clear with this? Now, coming to the application form that has to be submitted when the private placement offer has to be made. So this, when the private placement offer come application is made, it is made in form number PAS4. It has to be numbered properly. So there is a serial number on each application that it is issued, and it is addressed specifically to the person to whom the offer is made. So if the offer is being made to Ms. Sonali Shah, it will be specifically addressed. So it is only me who can subscribe to the securities. It's not that if I have received the offer, my entire family is free to make the application. No. It is addressed specifically to the person to whom the offer is made and has to be sent to him either in writing or in electronic mode within 30 days of recording the name of such person. So when the company identifies the people for making the offer and makes a list of it, within 30 days of recording that information, the form PS4 has to be sent to him. It is also provided that no person other than the person so addressed in the private placement offer cum application letter shall be allowed to apply through such application form. Right? So if a person does not conform to the requirement, that application will be treated as invalid. Also, there is an obligation on the company to maintain a complete record of private placement offers. So to the list of people to whom the private placement offer is made, that list will be maintained in PAS 5. And along with, so whenever the company wants to issue the private placement offer cum application letter, in that case, the company will issue the private placement cum offer application letter only after the special resolution or the board resolution permitting the same has been filed with the registrar, right? So the special resolution, the board resolution has to be filed with the registrar. Yes, Ramya, you are right. There can be debenture holders other than 200 members of shareholders. So shareholders and members of the company are different and debenture holders are different. Debenture holder are the people who have given loan to the company. Debentures are nothing but a debt form of money, right? Now, how do you subscribe to the private placement issue? What is the manner? So when the invitation is sent to the selected people, and if they are willing to subscribe to the private placement, they will have to fill in the form that is provided for the application that was issued along with the subscription money. So the application with the subscription money paid in check or demand draft or other banking channel will be submitted. Cash is not allowed. This money that is received by the company, it will be kept in a separate bank account, and it will not be used unless the allotment is made and the return of allotment is filed, right? And whenever there is a payment to be made for subscription to security, it shall be made from the bank account of the person who is subscribing to such securities. So if I have received the offer, I will file the application and the payment will also go from my bank account. It cannot go from my mother's, from my father's, or from my husband's bank account. It will always go from my bank account, from the person who has received the invitation, right? Now, talking about the situation where there are joint holders. In that case, the person who is named first in case of issue of shares, the money will be transferred from his account, right? Is that clear? Another requirement says that a company cannot proceed with a fresh offer or invitation until and unless an allotment has been done under previous invitation. So either the allotment has to be done or the previous invitation has to be withdrawn or abandoned to be able to issue a new or a fresh offer or invitation, right? Now, the law also prescribes for time limit for allotment of securities. What is the time limit? The time limit is 60 days here. In the case of public company, I think the time limit was 30 days, right? So here the time limit is 60 days. So a company which has made an offer for invitation, it will have to allot its securities within 60 days of receipt of application money. If he is unable to allot the securities, the company will have to refund the money within 15 days from the expiry of 60 days. From 61st day to 75th day, between this period, the refund has to be done. If the refund is not done, then interest will be applicable at the rate of 12% per annum from the expiry of 60th day. That means interest will be applicable from the 61st day, not the 76th day, right? So if the payment is not made within 15 days from the expiry of 60 days, interest will be applicable from the 61st day, right? Is that clear? Now, so just in case, whenever this money is received, this application money is received by the company, this money always has to be brought in a separate bank account in a scheduled bank, and this money can be used only for adjustment against securities allotted or for the repayment of money where company is unable to allot security. Also, we know that there is a prohibition of public advertisement. There cannot be public advertisement when there is a private placement of security. Whenever company allots the security, it will have to file a return of allotment within 15 days from the date of allotment in the manner prescribed by. So, what is the requirement when the return is to be filed? The return will be filed in form number PAS3 along with fee. It will contain the details of the allottees like name, address, PAN number, email ID, the class of securities held, the date of allotment of securities, the number of securities, the nominal value, the amount paid, the particulars of consideration received. All these information goes into filing, right? Further to that, what if the company defaults in filing of return of allotment? If there is a default, in that case, the company, its promoters and director will be liable to penalty of 1,000 rupees each day up to 25 lakh rupees. What is the punishment for contravening the private placement provision? It will be the promoters, the directors, and the company will be liable for penalty up to the amount raised through private placement or 2 crore rupees, whichever is lower, and they will refund all money with interest to subscriber within a period of 30 days of the order of imposing the penalty, right? And when there is a non-compliance of the provisions provided here, the offer will be deemed to be a public offer. Is that clear? Are we clear on the concept of private placement? Guys, are we clear on the concept of private placement? Any questions with respect to private placement? So if you try and sum up the procedure, what is happening here? Firstly, identification of person is happening. Special resolution is being passed. Invitation to offer come application form is sent to the selected person or the people who have been identified. They apply. If they are interested, they apply for the allotment of securities along with the respective money. The money is deposited in a scheduled bank account, in a bank account with the scheduled bank. If the requirements are fulfilled, the securities is allotted, return is filed in form PS3. If the securities is not allotted, within 60 days from receipt of application money, the money has to be refunded within 15 days from the date of expiry of 60 days. If the money is not paid, interest at the rate of 12% is applicable from the expiry of 60th day. And this is in totality the concept of private placement. Is this clear? What is this 0.8 that everybody is talking about? Point 8 is nothing but the class action suit, guys. I have already discussed class action suit. Why is this confusion happening on class action suit? Because I have mentioned it as class action suit and not suit by affected person, all of you are getting confused. Point 8 in your study material is nothing but the class action suits that I told you, which is section 37. There's nothing great in there. Guys, is it clear? If company defaults in filing of allotment of security, company defaults in filing of return of allotment securities, you are asking, Ashok? Please confirm your queries. Default, what are you asking? You are asking for punishment if the company defaults in filing of allotment of return for allotment of securities. Your confusion, your question is not clear, Ashok. Okay, I will repeat the private placement in summary, in totality of all the points that we had discussed. Okay, is that fine? So first point is key private placement is used by fundraising by every company, right? But in the case of private placement, the offer is made to selected people or the identified individual. Now, the first question arises, what is the limit of the maximum number of people to whom this offer for private placement can be made? So the limit is 200 of aggregate in a financial year. But this limit of 200 is applicable for each type of security. So the limit of 200 is for equity share, 200 preference share, 200 debenture share. So to 200 people, equity share can be offered. To 200 people, preference share can be offered. To 200 people, debenture can be offered. However, when we are talking about private company, we also have to remember in mind the limit of 200 members of a private company. So at no point can the limit of 200 members exceed in a private company. Is this clear? First point, limit of 200 members. Now, coming to the second point. the exception to the limit of members is not applicable to NBFC and HFC. So this company, the NBFC and HFC will be governed by the rules and regulations that are made by RBI and National Housing Bank for private placement. If the RBI and the National Housing Bank has not made rules pertaining to the same, they will be bound by provisions provided in Companies Act. Point number 2. Point number 3, how the private placement is made. People are identified, application in form PAS4 is made, and those form are issued to the selected individual whose list and detail is maintained, right? Now, whenever company wants to issue, make an offer for private placement, they need to pass a special resolution. However, there are certain situations where special resolution might not be needed. What are those situations where special resolution is not needed? Where the company is making an invitation for non-convertible debenture and the amount that it is trying to raise through that non-convertible debenture does not exceed the limit that is provided in section 181C, right? In that case, board resolution is enough. Second situation, where company is raising money through non-convertible debenture and it exceeds the limit of section 181C, in that case, passing a special resolution only once in a year for all the offer or invitation of debenture during the year is enough. Situation 3 is where the offer is being made to the institutional buyers. So where the offer is being made to the institutional buyers, passing special resolution only once a year is enough, right? So, right? Are we good till here? Now coming further, whenever a company is making such an offer, it will have to maintain a record, right? Now the record of the people to whom such an offer is to be made. But before issuing a private placement offer, the company will have to file the special resolution with the registrar, right? Once the application is received by the identified people, if they want, they can make an application with the required amount. The amount can be paid by check, demand draft, or other banking channels except cash. The money is deposited to a bank account which is mentioned in the specified bank. Another point thing, only the people who have received the invitation can make the application, and they have to make the payment from their bank accounts. Where there are joint holders, the payment will be made from the bank account of the person who is named first in the application. Next point is, a company cannot issue a fresh offer till allotment or withdrawal or abandonment of the previous application has taken place. So once the offer is made, application is received, the company will either allot the securities or it will not allot the security. So if it wants, it will have to allot the securities within 60 days from the receipt of application money. If the company does not allot the security within 60 days, it will have to refund the application money within 15 days. So from the expiry of 60 days to 15 days, it will have to refund money. So from 61st to 75 days is the window. If it does not refund the money between the window of 61 to 75, it will have to pay interest at the rate of 12% per annum from the 61st day. So from the expiry of the 60th day, the company will have to pay the interest at the rate of 12% per annum for not payment of the money. Company is not allowed to do a public advertisement, and whenever there is an allotment of security, the return has to be filed with the registrar within 15 days in the form number PAS3. If there is a default in filing of return, the promoter, the director, and the company is liable for a penalty of 1,000 rupees each day exceeding to 25 lakh rupees. And if there is a violation in contravening the provisions of private placement under section 42, then The company, the promoter and director is liable for penalty, which is extendable up to the amount raised in the placement or 2 crore rupees, which is lower. And they also be liable to refund the money with interest once the order is received within 30 days of receiving the order. And wherever there is a contravention of the provisions of a private placement, the offer will be deemed to be a public offer, as in where there is an extension of limit, the offer is being made to more than 200 people, there is an advertisement of offer, public advertisement, in that case, it will be deemed to be a public offer. So I just told you, Ashok, that if the company fails to file the return of allotment of securities, in that case, the company, the promoter and director will be liable for penalty of 1,000 rupees every day till the period default continues. So let's say if the company was supposed to file the return by 20th February and it filed the return only on 2nd of March, for the number of days the default was there, it will be liable for penalty of 1,000 rupees per day, but it cannot exceed 25 lakh rupees. So the liability is on the company, the promoter and director, all of them. What was your message, Shubham? Please explain with the wide will given more. Many of us are through direct entry, don't have commerce background. Shubham, if you do not have commerce background, I'm sorry, you will have to put in a little more hard work and work on the basics. Please understand there are limited number of classes that we have, and in that also we are running behind schedule. At my end, I'm trying to cover the maximum concept, but it might not be possible for me to explain each and every terminology because you are from non-commerce background. So I would request you to put in little more hard work and work on your concepts. Aditya, I don't know which marks you are talking about. If there are any specific points, whatever I'm covering in examination in terms of amendments and key points, that is more than enough. Okay, now coming back to Ritik's request where he wanted me to talk about the contents of prospectus. We are really short of time. We have to use the start the next chapter. Okay, briefly I'll tell you. So prospectus is a documentation which needs to be dated, it needs to be signed. The copy of prospectus needs to be submitted to the registrar. It contains a statement from the expert. It will contain financial information that are prescribed by the SEBI, right? It will contain the information. It will contain the information pertaining to the authorization of the prospectus. All these kind of information has to be there in the prospectus. Also, Ritik, please understand that I'm just left with 15 more minutes and I have to start your next topic. So I would request you to read the prospectus once on your own. If still you are not able to get through it, I will do it. But still, the key points for prospectus are that one thing, that it has to be dated and signed. It will contain information and financial reports that are specified by SEBI. They will contain declarations about compliance with Governing Act and the SEBI regulations. It is deemed that the date indicated on the prospectus is the date of publication. The prospectus must be registered with the ROC on or before the date of publication. Prospectus must be issued within 90 days of registration with the ROC. It can include an expert statement where the expert is not interested in the promotion management or in the affairs of the company. And the prospectus on its face will mention that the copy of it is delivered to the ROC for registration, and it must be truthful in all respects. So these are the key points that are needed for the prospectus. However, there are more details to it that you can do on your own. And also you must know that the regulations for the prospectus are prescribed by SEBI. So in totality, you will be able to understand prospectus when you read SEBI, but SEBI is not in your syllabus as of now. So only focus for the content that is provided here. If the private company exceeds the 200 member, it will have to convert itself into a public company. And a public company is also allowed to make a private placement. There is no limitation. But again, the private placement cannot be made to more than 200 members. In a financial year, in an aggregate, if you talk about aggregate in a financial year, it cannot be made to 200 people. Is that clear, Anmol? What was your question, Shobna? Ma'am, guys, explaining SEBI and how does it work is beyond the scope of my class. Please read it on your own. Amrisha, ma'am, the punishment will be either of the penalty prescribed and not both together in most of the situation. No, it depends. It could be penalty or imprisonment, and it could be penalty or imprisonment both, depending on the language of the legislation. Ritik, I just did the contents of prospectus for you. What else do you want me to know? The details of the contents of prospectus you don't have to do, guys. It is not there in your syllabus. Please restrict yourself to the content that is the key points that I've told you here. The details of the content of prospectus is not to be included. It is not there as per your new syllabus. Look at your new syllabus and stick to the study material that is provided by ICAI. Okay, now with this, we complete our chapter 2. And now, I'm sorry, this is chapter 3. Even I have got lost. Now we will proceed with chapter 4. My goodness, entire class has gone in chapter 3. Okay, guys, focus. Let's take a 1-minute break here before we proceed on chapter 4, okay? Let's take a 1-minute break and start with chapter 4 of Companies Act, which is share capital and debentures, right? So it's already 9:21, 9:23. We will start with new chapter, which is chapter 4. I hope all of you are through with chapter 3 and I was able to handle your queries. If I have missed queries for some students, I am sorry. Shubham is asking me, ma'am, please make chart for easy learning. सब मैं करूंगी तो तुम लोग क्या करोगे भाई? You want cooked food, right? But when you start working as a professional, the food will not be cooked, baby. You will be given only raw materials. You have to learn to cook your food. So I'm not giving you cooked dishes. I will only provide you raw material. You will decide what recipe you are going to follow. Bagan ka bharta banana hai ki you have to roast it. That is your choice. So making notes, making flowcharts, making summaries is very, very specific to the person who is studying it. Everybody has their own understanding, their way of writing, the way of remembering things. Someone might like to remember in English, someone might like to remember in Hindi, someone might like to associate with Tenali Ram ki stories. So this is all very, very specific to the person. So please make flowcharts and notes on your own. I am sorry, I am not the person who will give you ready-made charts. We can have charts at the time of revision. I will draw in the charts. I will use charts for revision purposes when we do a revision class, but not now. Not now. Yes, Lalita, you are right. The limit of 200 is applicable to every sort of company, and that limit is limited to every class of securities. And Limit is an aggregate in a financial year for every class of securities, right? And it is applicable to public company as well. And also when you are determining the limit of 200 members, you do not include the qualified institutional buyers and to the employees to whom the securities have been allotted under ESOPs. Okay, is that clear? Now, quickly wrap up with chapter 3. Come on, chapter 4. Guys, done here. Srishti, your query on preference shares, whether they'll be deemed to be convertible or non-convertible, I will clarify in the upcoming sessions. Priya is asking me, ma'am, how do we remember concepts? Read, make your notes, revise. You can go through the old module, but you will have to see that you cover up the amendments, Ashok. Meanwhile, I am trying to include the maximum number of concepts as far as I could. However, I will try to include more examples which can help you associate. But you need to understand quoting practical examples is really not possible for everything in company law. You need to understand legislation. It talks about facts and guidelines. There cannot be an example to everything. Right? Shubham, I know, I'm glad that you have an amazing faculty for audit who is making learning very easy for you and her teaching style is good. I'm really sorry if my teaching style is not good and I will try to improvise. As a teacher, I am also improvising day by day. See, in a class of 500, 600 students, there will always be some who will not be convinced my style, but there will be a lot more who will be convinced. So I think it would be difficult for me to make every student happy, right? Guys, any other queries on this? Okay. Under chapter 4, I will not take up the sections, but let me just give you a brief. I know it has become too much and it will cause confusion to you, but let me give you a brief that in the chapter 4, we are going to talk about share capital and debentures. So we know there are companies which are incorporated with share capital. So under this chapter, we will talk about the different types of share capitals, like the equity, preference share capital, the debenture share capitals, about the differential voting rights. So all these concepts of share capital we would be covering in this chapter, right? What are the sections that are covered? Section 43 to section 72 are covered under chapter 4. However, few sections have been removed for the syllabus: 44, 45, 60, 65, and 72, right? So these are the 5 sections that have been removed from your syllabus. So section 43 to 72 with exclusions, read with company share and debenture rules 2014. We will be studying them as part of chapter 4, share capital and debentures. This chapter I will be starting in the next class. And when you come to the next class, I expect the students who are not from commerce background at least to read certain basics so that when you're there in the class, you are able to comprehend on what I am talking about. Because otherwise it will become very difficult for you to catch up, guys. And it is difficult for me to teach you the commerce of class 11th and 12th. Ronal, very soon the timetable for March will also come in. So the entire syllabus will be completed. Don't worry, I'll be taking the entire syllabus. Companies Act, the entire syllabus I am taking. Gitanjali, you don't need to write examples in your In exam, you will have to apply the concepts to the question that is provided, and you don't need to write examples are there in your study material for your understanding purposes. So some students are asking me to give them an idea of charts or how to make chart. So if you would have seen my previous presentation that I was sharing with you, the one we were talking about. So if you see here at the end, I had made a chart pertaining to failure in allotment of securities. This is how you make chart. You break down thing into boxes. You draw arrows and then write it. There's nothing difficult. See, guys, it all depends on your understanding on how you break down things. Like, for example, see, I've made this note I'm showing to you. I don't know if all of you can see this. So if you see, this is my way of writing the notes, right? So there is underwriting commission written here. I have broken down into things, used colored pens. So every person has their own ways of writing. Imagine I have been working for so long. I have been teaching you guys for so long. Still, I make notes for the classes that I take. I still use colored pens. I break it down. I draw into flow chart. Now, what I write here is based on the points what I need to remember or how I need to say it. How you would remember it depends on you. Like for underwriting commission, I told you the mnemonics of NCD par. You can make your own mnemonics. There is no rule that you have to remember it through NCD par. You can remember it, Niti, China, deposit, whatever. So these are the ways of learning, and everybody has their own style. As a teacher, my responsibility is that when you read on your own, you are able to understand the concept that we are talking about. Once you understand the concept, remembering it in a brain is a different thing. It's a memory thing, right? But if you don't understand the concept and you just want to mug up the things, that will not help you attempt the application based questions that you get to see in your examinations. Is that clear? I think the classes for both the group will finish by maximum by mid of April. Guys, I don't have any idea on the fees for you. I'm sorry. Any other queries, people? Shoaib is asking me the limit for private companies 200 member. Then how will it issue invitation to 200 equity shares and 200 debentures at the same time? Shoaib, it is not necessary that the debenture holder of a company is the member as well. This is why I told you that when the invitation for private placement is made for a private company, we have to keep in mind the limit of provided in the section 268 as well. So when you look at the private placement thing, it says that the limit is an aggregate of 200 in one financial year for each class of securities. However, when the application or offer is by a private company, then we have to ensure that at no point the number of members should exceed 200, right? Guys, we will be having a class for case study based questions. Don't worry about that. Even if you look at your study material, there are a lot of questions given at the end. We can take a few questions one by one. All of you can open your study material if you want. Rather, I will open it up here for you and we can take up some questions. I think that will be helpful for you. So I think all of you can okay. All of you could see my screen. Let us take a few questions that have been provided for in your study material. I'll explain them to you. I think that will be really helpful. Okay. Let's see this question which says, Unique Builder Limited decides to pay 2.5% of the value of debenture as underwriting commission to the underwriter, but the articles of association of company authorize only 2% underwriting commission on debentures. The company further decides to pay the underwriting commission in the form of flats. Examine the validity of above provision. Do you think how will this follow? So firstly, since the articles of association prescribes the underwriting commission to be 2%, that is the maximum amount that can be paid to the can be paid by way of underwriting commission, right? So the decision of Unique Builder to pay underwriting commission exceeding 2% is invalid. But can the company pay underwriting commission in the form of flat as well as money? If you look at the language of Companies Act 2013, it nowhere specifies that the payment has to be done only in the form of money. It only says that it has to be from the proceeds of the issue of shares, or it can be paid out of profit. How it will be paid, that is open to the company. So a lot of times there can be underwriting agreement where something is paid to the underwriter in return of something. So there can be such terms of the agreement. There is nothing wrong with that. Let us take one more question. PQR Bakers Limited wants to raise fund for its upcoming project. Accordingly, it has issued private placement offer letters for issuing equity shares to 55%, of which 4 are qualified as institutional buyers and remaining are individuals. Before the completion of allotment of equity share under this offer letter, the company issued another private placement offer letter to another 155 people in their initial names. Being a public company, is it possible for PQR Bakers to issue securities under private placement offer? By doing so, whether the company is in compliance with the provision? What if the offer for debenture is given after equity of shares? So first thing is that first offer is made to 55 people. Out of 55 people, 4 are QIB. So when we are counting the limit, we will not be including these 4 people. That means we have 51 people given here. Right? So we have 51 people here. Further, it issues to more 155 people. When you sum it up, it comes to 206 people, right, in their individual capacity. Now, so here you also need to say that the 55 people to whom the offer were made, the offer is made for allotment of equity shares, right? And to another 55 people, they were made for issue of debentures. So the limit of 200 that you see, that is for each class of shares, right? So each class of security. So for private, for equity or shares also it is 200. So for debentures also it is 200. Thus, it appears to be well within its limit. So further details you can read on your own. So these are the kind of questions you will be getting to see on this chapter. Remaining questions, you can look at it on your own. They have been provided for and you will be able to understand them. If there is any query, you can always get into details. How to identify the case-based question. In the case-based question, guys, what happens? There will be a lengthy question with certain facts. So there will be like Mr. A purchased this from Mr. B, so and so happened. And based on that, there will be questions. So there will be some MCQs followed by a detailed question. So this is like a case study based question that you get to see in your examination, right? Is it fine, guys? So with this, we complete our chapter 3. In the next class, we will be starting with chapter 4 of our syllabus. I've tried my best to explain things to you to cover maximum number of queries. However, if I was unable to take queries of some students, I'm really sorry for that. And another request, students who are not from commerce background, please brush up the concepts for the next class and then attend the class. It will become much more easier for you to understand the situations and things. And for students who are requesting me to include more stories, trust me, guys, you are grown up, and there are certain limitations of the classes that we take here at ICAI. So I'll try to include more professional stories, whichever I can. So with this, we finish our class for today. All of you have a good day. Take care and stay safe.